Okay, great. Thank you, MSBA. This is another rendition of PPP. I actually think this will be the end this time, based on the new legislation and the new current guidance. My name is Rebecca Shepard. I'm a tax attorney. I'm a senior associate at Frost Law. I'm here with Peter Huckabo, who is also a senior tax attorney here. We work together. We typically deal in tax controversies and those types of matters rather than PPP, but the last few months, this has kind of been our game. So we are excited to present, we think, the last PowerPoint on this, PPP Flexibility Act. What Congress did, changed everything and made it a lot more beneficial to businesses and specifically sole proprietors. If you have any questions, please feel free to shoot them over in the chat. We have reserved about half the time for questions, so don't hold back. So I think most of you are aware of what the PPP program is, but there's still $130 billion out there in this program. The application deadline is June 30th. And so we really, if you have not applied for the loan yet and you don't think that you qualify, give one of us a call. We're happy to do a couple minutes here and there just to kind of go through whether or not you're eligible and to get that application in. Like I said, there's $130 billion, and there's been some recent requests by some Democratic senators to extend the deadline to December 31 instead of June 30th, but it has not gone through yet. And as you're all aware, it is June 25th. So time to do it. There's places still accepting applications. Cabbage is accepting through June 28th at 11:59 p.m. And PayPal, I believe, is also still accepting. I don't know if bigger banks are still taking applications, but something to be aware of, that these other relationships you can go through. So the PPP, what is it? So on June 5th, 2020, the Paycheck Protection Program Flexibility Act of 2020 was signed into law, which amended the CARES Act. So we just kind of wanted to go through and recap for you what the PPP is, whether or not you'll apply. Can you go to the next slide, Bill? So if you haven't applied yet, like I said, this is the time to do it. No time like the present. You do not need to file your 2019 taxes or anything like that. You need a draft Schedule C for 2019. I actually have a banker who's taken a P&L before, so I guess it depends on what your bank is requiring. But this is the time to get your documents together and to go ahead and apply. The application amount is the maximum loan for each borrower will equal the lesser of $10 million, or the average total monthly payments by the applicant for payroll costs incurred during the 1 year period prior to the date on which the loan is made, multiplied by 2.5, plus the outstanding amounts of any emergency injury disaster loan obtained on or after January 31st, which is to be refinanced under this loan. The interest rate on loan under the Paycheck Protection Program is 1%. And as far as if you're a sole proprietor, you don't have payroll and you don't know whether or not you qualify, you would take your profit from your Schedule C on line 31 for 2019, divide it by 12 and multiply by 2.5. You're capped at, well, can you go to the next slide? So who can apply is any small business concern that meets SBA size standards, either the industry-based size standard or the alternative size standard. Any business, 501c3 nonprofit organization, 501c19 veterans organization, or tribal business concern, Section 31B2C of the Small Business Act with less than 500 employees. Sole proprietors, independent contractors, and self-employed persons can apply. And like I said, in that application, you are going to be capped at $100,000. That's the maximum amount somebody can earn through a wage or earn as self-employment income. So if you made $200,000 in 2019, and that's what your line 31 says, you're going to be capped at $100,000. You would divide by 12 and multiply by 2.5. So your loan amount is going to be $20,833. And the same for any employee that made over $100,000. That's for cash compensation. If you have employees that also had employer retirement contributions or employer healthcare contributions, you can include that in your loan number. And again, Peter and I are happy to take a random question here and there if you would like to give us a call just to kind of run something through. So once you've applied, you've gotten your loan, super exciting. Now you're ready for forgiveness. So forgiveness generally, the amount of loan forgiveness can be up to the full principal amount of the loan and any accrued interest. An eligible borrower will not be responsible for any loan payment if the borrower uses all of the loan proceeds, 1, for forgivable purposes, and 2, employee compensation levels are maintained, or if not an applicable, safe harbor applies. The actual amount of loan forgiveness will depend in part on the total amount of payroll costs, payments of interest on mortgage obligations incurred before February 15th, rent payments on leases dated before February 15th, and utility payments for services that began before February 15th over the loan forgiveness covered period, excuse me. The next slide. So when Congress originally enacted the CARES Act and the guidance, and by the way, I read today that there has been 18 different IFRs that have come out, which is why you've seen me and Peter so many times during this period. We were chatting last night that had this been the original plan, we would have done one presentation, everything would have been forgiven, and that would have been the end of it. And instead, they've drawn this out since March 23rd, I believe, is when it was enacted, March 24th, something like that. And it is June 25th, and we are still talking about this, which is, I think everyone's a little tired of it, frankly. None more than me and Peter. But originally, you're only allowed to use you had to use up to 75% of the loan proceeds for payroll costs, and only 25% could be for non-payroll costs. Restaurant owners, hotels, a lot of businesses lobbied Congress and said, this is not fair. My business isn't even open. Why would I have payroll costs up to 75%? You need to reduce this. I think some versions of the law, they said, well, there'll be no requirement to have payroll. People got upset about that because the point is to get people off unemployment and to make sure they're being employed by their company. So they agreed to 60% of payroll costs and 40% for non-payroll costs. This really does allow for most of the loan to be forgiven. There's some other rules that we'll get into that make it so everything should be forgiven at this point. And we'll kind of explain how that's going to impact you. What does that mean for tax purposes? What does that mean for your business, et cetera? But so 60% to receive full loan forgiveness, a borrower must use at least 60% of the PPP loan proceeds for payroll costs, and not more than 40% of the loan forgiveness amount may be attributable to non-payroll costs. That 60% number is not a threshold or a cliff. It's a percentage of forgiveness. So you're always going to get something forgiven. It's not like if you hit 50% of payroll costs that you would lose the entire forgiveness amount. It just means that you would lose about 10% of your loan, as your 50% would be converted to 60% and part of the loan would not be forgiven. I'm going to go to the next slide. All right, what are payroll costs? Great question. The sum of payments of any compensation with respect to employees, that is a salary, wage, commission, or similar compensation, payment of cash, tip, or equivalent, payment for vacation, parental, family, medical, or sick leave, allowance for dismissal or separation, payment required for the provisions of group healthcare benefits, including health insurance premiums, payment of any retirement benefit, or payment of state or local tax assessed on the compensation of employees, and the sum of payments of any compensation to or income of a sole proprietor, independent contractor that is a wage, commission, income, net earning from self-employment or similar compensation, and that is an amount that is not more than $100,000 in 1 year as prorated for the covered period. And payroll costs do not include, as we said, compensation of an individual employee in excess of an annual salary of $100,000 as prorated for the cover period. You do not get credit for employer portion of FICA. This is actually left over from the CARES Act. Taxes imposed or withheld under chapters 21, 22, or 24. You can ignore that. That's been changed with recent guidance. Any compensation of an employee whose principal place of residence is outside the United States is not going to count. Anything that you've already received FFCRA money for, you're not going to be able to count that payroll period as well. When the covered period was 8 weeks, this is something that we sweated a little bit. Where it was like, well, what do you do in this situation? What benefit is better? Covered period is now 24 weeks. And so you should be able to utilize both credit programs and not have a problem. You know, for weeks 1 to 3, you get FFCRA money, and then from 3 to 24, use PPP money. You should still be really good to use all of your funds, assuming that you know, you're back in operation. Go to the next slide. So what are non-payroll costs? Mortgage interest payments, but not mortgage prepayments or principal payments, rent payments, utility payments, lease payments, interest payments on any other debt obligation that were incurred before February 15th, 2020. To the next slide. And I believe we are going to kick it over to Peter, who's going to explain about the FTEs and what can limit your forgiveness.
Yep, thanks, Rebecca. So this is where the fun happens. But before we get into some of the new safe harbors, let's just do a quick recap of what else is out there, because there's a lot with FTE and with wage reduction. So the regular rule, the rule from the original CARES Act, says that you can be your forgiveness can be reduced to the extent that you have reduced FTEs during your covered period compared to certain reference periods. So the original reference periods are February 15th, 2019 to June 30th, 2019, or January 1st, 2020 to February 29th, 2020. And you're comparing that either to your 8-week or now, this is new, 24-week covered period. If you don't have a reduction, you don't have an issue with FTE. Now, the original wage reduction rule is that you can't reduce someone's wages more than 25%. And what we learned in some of the recent guidance is that you are definitely looking at quarter 1, and you are comparing that to either the 8-week or the 24-week covered period, depending on when you received your loan. Then, a couple of these IFRs later, they came out with these safe harbors that sort of tracks back to the language of the CARES Act, but the FTE safe harbor was that if you reduced your FTE count from February 15th to April 26th, but restored it by June 30th, and now that's December 31st, 2020, not June 30th anymore, then you can avail yourself of the safe harbor. And even if you had a reduction, but you restored it on or before December 31st, you would be able to use the safe harbor. Safe harbor for the wage reduction is that you restore now by December 31st to a level that you had between February 15th and April 26th. Now what we have in the Forgiveness Act and the Flexibility Act and the regulations that have come now after are 2 more safe harbors. But actually, before I get into that, I want to remind you also that there were previously 4 exceptions that would operate to limit any reductions, and that was a good faith offer to rehire, that was written, it was rejected, and that you tell the state. There was also a termination for cause, voluntary resignation, or a reduction in hours that was requested by the employee. So what these new regulations, the IFR that came out on Tuesday, what it says is that first exception is now being superseded. So you no longer have this good faith offer to rehire, written, rejected, tell the state. Now, that's superseded by this slide, by safe harbor number 1. And what it's basically adding is the requirement that there were no similarly qualified employees that could have been hired. So you still have the obligation to make a good faith offer to rehire. That rehire needs to be at the hours and the rate that they were being paid before they were furloughed or terminated. It needs to be rejected. All of this needs to be documented. But in addition to that, so it's not an or, it's an and, you have to be able to show, and this needs to be documented, that you tried to hire a similarly qualified employee and were unable to. In addition to all of that, it's still maintaining the requirement that within 30 days that the former employee rejects your offer, that you need to reach out to the Department of Labor and let them know that this person really shouldn't be on unemployment anymore. And I saw some emails came out from the Department of Labor this week clarifying how you do that. So that is the first new exception or safe harbor. And Bill, you want to go to the next slide? So the second one is a pretty big catch-all, that if you're not able to return to the same level of activity, business activity, that you had going on February 15th, 2020, and the reason that you can't is because of guidance that was put out by Health and Human Services, the CDC, or OSHA related to coronavirus, social distancing, principles of cleanliness, that kind of stuff. That was issued between March 1st of 2020 and the end of the year. You know, if you can't get back to that business level, then the FTE reduction is not going to affect you. And this includes stay-at-home orders, other orders that maybe didn't come from HHS, CDC, or OSHA, but that are based on the guidance that came out from them. So Governor Hogan's, stay at home, what is an essential business, all that kind of stuff. I think gets pulled into this safe harbor. So these two new safe harbors are massive.
Can I just hop in for 2 seconds? If you're an attorney where you have jury trials and things like that, that would also fall under this COVID-19 exception, because the courts have been closed. So it doesn't necessarily mean that you have to have social distancing in your workplace, and that's why you get the safe harbor. You know, you're directly affected by what the courts are doing, and therefore you would qualify here as well.
Yeah, and the courts are making these decisions based on the guidance that's coming out from these federal agencies. So, there's a couple of parameters here, something that came out between March 1st and the end of the year. I don't think that's going to be an issue for a lot of folks. So this one's massive. So to the extent your FTE is reduced, this is not going to affect it. Rebecca referenced it earlier, but the loan forgiveness covered period has been extended from the original 8-week period to a 24-week period. So this is also massive. Now, anybody who received their loan after June 5th, and June 5th is the date that the president signed the PPP Flexibility Act of 2020 into law. So anybody who gets their loan proceeds after June 5th is automatically in that 24-week period. If you got it before, and we've been working with a bunch of clients who have been very diligent in planning this out and making sure that they were going to, use all the funds by their original 8-week covered period, you can still elect to use that. You can get this off your books. You can, once that 8-week period is over, you don't have to wait for the 24. Next slide. So submitting to your lender must notify you of remittance by SBA of the loan forgiveness amount and the date of your first prepayment. So keep in mind that the banks are the ones operating this program. This PPP is built on the existing 7A program that's administered by the banks, but it's an SBA program. So the application for forgiveness is going to the bank or the fintech firm in the same way that you made the original application. They are then certifying to SBA that you meet the requirements for full or partial forgiveness. And it's at that point, so what the Flexibility Act also did was extended forbearance for longer than just the original 6 months. So originally it was 6 months after you received your loan. What it does now is there's no payments on it until the bank has made a determination on your loan, as long as you, and I think there's a slide later on this, but as long as you apply for forgiveness within 10 months of the end of your covered period. So definitely giving you a lot more time. Just a reminder, interest does continue to accrue during the deferment period, and the loan forgiveness of any period of loan forgiveness covered period of any borrower will end no later than December 31st, 2020. So that's why when you back it out, June 30th is a real deadline. Right now, the banks, the banks cannot go get an E-track number from SBA after June 30th. And so that's why some of these banks are cutting them off early, because they need a couple of days to do their due diligence. You add 24 weeks and that gets to the end of the year. Next slide. And this is what we talked about. If you do not submit your lender a loan forgiveness application within 10 months after the end of your loan forgiveness covered period, you must begin paying principal and interest. And for example, if a borrower's PPP loan is dispersed on June 25th, today, the 24-week period ends on December 10th. If the borrower does not submit the loan forgiveness application to its lender by October the 10th, 2021, the borrower must begin making payments on or after October 10th, 2021. You wouldn't want to wait. I mean, interest is accruing, so to the extent you have the ability to start repaying, no reason to wait on that. All right, going to the next one, Bill. So I don't know if we got into this. These webinars are becoming a blur. So I'm not sure if this is something that we talked about, but definitely something to bring to your attention. The text of the CARES Act, the actual original CARES Act, says, the forgiveness of these loans is not going to generate income. And that's important because, from a tax perspective, when someone has a repayment obligation, that's a loan, that's not income. But when that repayment obligation is canceled, that gives rise to canceled debt income. And so it was really important to see that provision in the text of the CARES Act. Next slide. What the IRS, what Treasury has done in the interim is come out with Notice 2020-32. And what this is an analysis of Code Section 265 and the regulations under it. Section 265 basically says you don't get a deduction. You aren't able to deduct expenses related to the generation of tax-exempt income. And so the consequence of that is Treasury's position at this point is that you don't get to claim as an expense any of the stuff that you have forgiven. So in effect, unwinding the provision in the CARES Act that says this is not income, because you're not going to get the corresponding exemptions, deductions. The practitioner community, CPAs, this has not sat well with us. And the distinction here is that there is a very big distinction between tax-exempt income and an exclusion. It may seem like a difference without a distinction, or distinction without a difference. That's not what's going on here. Not only does it certainly not track back to, we think, the original intent of this, and that is expressed in the CARES Act, but sort of goes against some tax principles as well. So I was surprised not to see a fix about this in the Flexibility Act. That's not to say that a legislative fix is not happening, but it hasn't happened yet. So the call to action here is to pay attention to this stuff, have a conversation with your tax preparer, work with a professional next year on this, because it's potentially going to become an issue. Next slide. So one of the things that we do want to draw to your attention, in earlier webinars, we've tried to identify some of the other programs that have been out here. PPP is obviously the biggest one, but there's other ones out there, and we've tried to identify where PPP plays nice with it and where it doesn't. And up until the Flexibility Act, PPP did not play nice with payroll tax deferral principles. So it was, you could do one or the other. And I recall Rebecca saying, look, maybe you can try to do both because it's not really an issue until you have your loan forgiveness ruled on. What this made clear, and big picture, payroll tax deferral. As of March 27th, businesses may defer the employer portion of, and this is a typo, it's not payroll tax, it's the employer portion of Social Security tax. So the 6.2% for Social Security tax, not the 1.45% for Medicare. But they may defer it from March 27th through the end of 2020. Next slide, Bill. And what they then do is they have to, you still have to pay it, but you can pay 50% by December 31st, 2021, and then the next 50% by December 31st, 2022. So a very long deferral. Previously, you weren't allowed to participate in PPP and also do this. The Flexibility Act said it's fine, you can do both, but it's only for the Social Security, not for the Medicare portion of that. Next slide. And then what was also clarified through guidance and through the Flexibility Act is if you're self-employed, if you're a Schedule C filer, sole proprietor, independent contractor, self-employed, you can also do this, and you can defer part of your estimated tax, 50% of your estimated tax payments as well. Next slide. To the extent you have made payments and you want a refund for it, you can file Form 7200. That's now available on irs.gov. You would file this form and ask for a refund. Next slide. And I will toss it back over to Rebecca.
All right. So thanks, Peter. That was a really good explanation of the tax credit deferrals. I just kind of want to highlight the fact this is huge. First of all, as tax attorneys, the government never tells you not to pay your taxes. So that's like amazing from our perspective. Like, okay, things are bad enough they're telling you not to pay their taxes. Not only do you not have to pay them right now, you can defer them for 2 years. For those sole proprietors that are out there waiting for courts to open and things like that, this is huge. It's a 0% loan for a really long time. The first payment is due in 1.5 years, and the next one's due in 2.5. It's really worthwhile to think about. Obviously, if your firm is doing fine, it's not an issue, and you want to just pay it, so it's not something that's hanging over your head, fine. But for those of you that aren't, I talked to a landlord-tenant attorney yesterday in California. So I think Maryland is probably very protective over tenants. California is probably slightly more so. She's having a really rough time. This is the time for these types of programs. This is really going to help you through this period. And we don't know, what the fall brings, what the winter's going to bring. So that Form 7200, there's no time frame on it. If you're doing okay right now and in a month you're like, oh man, I wish I had opted for that payroll tax deferral, go ahead and do it. And then take that 0% interest loan and then pay your Social Security tax later. I really think this is one of the best things that kind of came out of the Flexibility Act. Not the Flexibility Act, but the Flexibility Act. Obviously 60-40 is great and 24 weeks is great, but this is for people who are already going to spend the money. It wasn't an issue. This is their carrot. This is like an extra thing for them that they're able to do. So on June 16th, 2020, the SBA issued an interim final rule. I guess that was number 17 because one also got issued on Monday night. Increasing the limit on forgiveness of owner compensation for self-employed individuals who file a Schedule C or F. This is also a typo. We apologize. It's also for S Corp owners. So the limit has been set to either 8 weeks worth, 8/52 of 2019 net profit up to $15,385. We already knew that. And for an 8-week period covered, or 2.5 months worth, 2.5 over 12 of 2019 net profit up to $20,833 for a 24-week covered period. So this is really incredible. Before, Peter and I were like, what about the sole proprietor who works from home, who is only able to get $15,385? What are they supposed to do with this extra $5,000 that they got? Are they going to have to hire someone? So I was talking to people about, like, this is the time to get your website developed. This is the time to hire a marketer, get a legal intern to do whatever project you've wanted to get done. This is your money to do that with. Well, hopefully they were waiting to have, the 17th guidance issued, because now they can actually take it for themselves, and it's all owner compensation, and you're fine. It doesn't impact you at all. And just one other item. This is going to be an example that may not be applicable to everyone, but just something to think about. Because of the tax treatment that Peter discussed earlier, if you're a Schedule C, so say for 2019, it was just you had $20,833 a loan amount. And then for 2020, you hired someone. So now you've been paying your employee and you're paying yourself. I would still take the $20,833 as owner compensation, because then you're being taxed on it, and you'd be taxed on it anyway. And you can still subtract out that wage expense from your taxable income in 2020. So things like that, that's something to think about as far as going forward. I know that's a really unique example. Not everyone's going to fit that example, but people are going to have similar situations. And if you are a Schedule C, I say max out your profit if possible, just to get the best tax treatment going forward. Go to the next slide. All right, these are our key takeaways. Exciting. PPP Flexibility Act amends the Paycheck Protection Program to give borrowers more time to spend loan funds and still obtain forgiveness. Borrowers now have 24 weeks to spend loan proceeds, up from 8 weeks. The act also reduces mandatory payroll spending from 75% to 60%. 2 new safe harbor exceptions let borrowers obtain full forgiveness even without fully restoring their workforce. Time to pay off the loan has been extended to 5 years from the original 2. These are for loans that were enacted after June 5th. Prior to that, take it up with your bank, see if they'll let you expand the terms. Probably not, because these are not great loans for banks to have. The 1% interest is not too favorable to banks, but you never know. And the act now lets businesses delay paying employer payroll taxes even if the business receives forgiveness. And then again, what Peter was talking about as far as the tax treatment goes, things to think about. After, I want to say, guidance number 10, Peter and I did a whole presentation regarding alternate covered period and incurred and paid, and what can you do here. And we were trying to fit all of these strings through these needles, and we were trying to be super precise about it. Well, if your electric bill was due on May 31st, and your period, you got billed on June 10th, and your loan amount went through June 5th, you'd be able to take that full utility payment. That stuff doesn't really matter anymore because of the extended cover period. Glenn Frost, who's our boss, actually said, like, what are you going to call your presentation? Just kidding. It's all forgiven. Like, it's a lot of it can get forgiven now. If you don't believe that you're able to get your full loan forgiven, give us a call. We're happy to help you kind of work through that, because it can certainly all be forgiven at this point, given the 24 weeks to spend your proceeds, given the fact that owner comp is extended to that full loan amount. It really is beneficial to business owners. And that's been kind of the point of all of these different IFRs and all these different iterations and new laws and et cetera. They've just been better and better for businesses as they go. Everything has been beneficial to the business owner, and which makes it more beneficial to the employee. Just one other thing, there is some new legislation that has been proposed. It's actually got bipartisan support. There's one bill in the Senate and one bill in the House. I think it's called P4. And they're talking about if you've already extinguished all of your funds, in a way for you to get new funds. So if that's something that you're interested in, we suggest that you look into that. We're not sure if it's going to be passed, obviously, but the rules there, just quickly, are that you have to have 10 or less employees. So for a lot of sole practitioners, that's something to think about. Your income has to go below 50% from pre-COVID. So again, the landlord tenant attorney in California, this speaks to her. She's looking forward, hoping this passes, because she hasn't seen income in months, and she's looking, at a December date, I think, from when she can start, forcing tenants to abide by those leases. So something just to kind of keep your eye on there. So there's that legislation package, and then there's another one trying to extend that loan date. So if you haven't applied for a loan yet, I would still say do it now, but you're not totally out of the woods. I actually spoke to a client last night who hadn't been getting back to me because she just assumed she wasn't eligible. And she finally got back to me yesterday. And I was like, you're eligible. Like, this is the time to apply. Like, do it tonight. Just do a draft Schedule C. Make sure it's as good as it can get. If you don't include everything in there, it's okay. And just get what you can over there in good faith. So that way you can be considered for this program. So those are my takeaways. Peter, do you have anything else to add on the takeaway?
No, not on the takeaway.
Okay. I think is that our last slide?
No, there's
we have
one
a
more.
thank you. Okay.
No, there's one more. So this was the other big thing that happened, I guess, this week. This Thursday? Yeah, it was Monday or Tuesday. So SBA came out with a new form. So initially, back they came out with Form 3508, which was the long form for forgiveness application. It had an attached Schedule A where you were reporting, payments to individuals, how much and who they were, and what their socials were, and really digging in deep. Form 3508 EZ is much simpler. It's ostensibly a one-page form where you are just top line reporting payroll cost, non-payroll cost, double checking to make sure you hit the 60%. But you're making some additional certifications. And because this EZ form is really only created for 3 groups of people. The first one is that you are a self-employed independent contractor or sole proprietor with no employees at the time that you made the application for forgiveness, and whose loan amount does not include any employee salaries. So this is the solo practitioner, no employees, you can certify this. The next 2 basically track back to the new safe harbors. So either you didn't have, any reduction in FTE, and you didn't have, you didn't cram down people's wages more than 25%. But if you did, do you fall into one of those 2? And again, those are that you tried to rehire, they didn't take you up on it. You've documented all this stuff. You've identified them to the state that they didn't accept reemployment. And remember, it's an and, you weren't able to find other qualified employees to fill the role. So that's number 2. Then the third one is, you didn't reduce people's wages, you didn't, reduce FT, but if you did it because you weren't able to get back up to the February 15th business activity based on guidance published by HHS, CDC, OSHA, related to the maintenance of standards, sanitation, social distancing, and any other work or customer safety requirement related to COVID-19. So, in addition, they've relaxed these FTE rules and added these safe harbors. We were hopeful, and I think I saw a letter that was circulated to the Treasury and SBA saying we want blanket forgiveness for any loans under $1 million. We haven't seen that yet, but this certainly appears to be an attempt to make the loan forgiveness stuff a whole lot easier, which is a step in the right direction. But you're still going to need to track some of this stuff, but in no way are you reporting in as detailed of a way if you can fit into one of these 3 buckets.
Awesome. Thanks for that. There is also still a new long form. forgiveness application, like Peter said, the banks have really been pushing for a better way, because it seems like as all this legislation's kind of come through, and just kidding, everything is forgiven. Why not just do it one step further and say, okay, for real, everything is forgiven. If you've got a small loan, $1 million is probably pushing it, but maybe like 150,000 or something along those lines would make a difference.
The banks are asking for it. They don't want to mess with this stuff anymore.
They don't. They're done. But there is, so if you did get a loan for over 150,000, just know that there was a recent decision where Treasury kind of went back on their word about publishing those loan holders or applicants. So your information will be out there if you've got a loan for over 150,000. And they said that 75% of the borrowers was actually under 150,000. So it would make sense that if that's the kind of 75% or more is over 100 or under 150,000, that would be like kind of the number they would go with. A lot of it is just speculation at this point. But since they've issued 18 different IFRs, so you guys have to understand that during COVID, Peter and I have gone through these things 18 times, going through, and they don't like do a nice little like, hey guys, we changed this one thing. They issue the same IFR and you have to actually read through every single piece to try to figure out what's different and what's the same. It's a really good time. So that's what we've been going through. So we've got a couple of questions. We're definitely happy to help anymore. We've got a lot of time scheduled for questions. So even if your question feels really specific, we have a smaller group, we're happy to help. Why not take our time now versus, calling later or making a mistake. We're happy to do it. So the first question is the extended cover period applicable to all PPP owners? Yeah. You don't have to actually do anything if you want a 24-week period. The only time you have to do something is if you want to elect for your 8-week period. There is new guidance that was just issued yesterday regarding how to apply. And so in a different seminar I was doing, people were asking like, well, I don't need 24 weeks. I do want 12 weeks or I want 13 weeks. Can I just apply when I'm done at 13 weeks? And the new IFR says that you can. You just want to be really careful and make sure that you're doing everything properly. If you did reduce FTE or if you did have a salary reduction, I would say just wait for the full 24 weeks to make sure that you get to be able to access that safe harbor and to use all the compensation properly. If not, if you haven't laid anyone off, if everything else stayed the same and you're good and you just want this loan off the books, go for it. That's totally fine.
The only thing that we'd been kicking around within the office, and I don't know necessarily where we've settled on it, but now that you've got this situation where a self-employed person is able to go above the 850 seconds and they're able to get the 2.5 over 12, maybe just wait the 2.5. Maybe you don't have to wait for the full 24, but at least wait the 2.5. We don't know. I mean, it's not addressed specifically on point in these IFRs, but maybe as a best practice, maybe a good idea.
And there's no harm in waiting unless you're just like dying to get this loan off the books. There's no reason that you can't, just hang out a little bit so that way you're sure that your entire loan amount will be forgiven. And just one other thing before I get into the next question. The EIDL was just reopened like last week with new money. So if that's something that you wanted to pursue, again, that landlord tenant attorney, I'm just going to keep talking about her apparently. She needed an EIDL because she has no income coming in whatsoever. So it depends on like what level of distress that your business is in, due to COVID and for all of these things. But if you want a loan, the EIDL for terms are also very favorable, not as favorable as the PPP because like, I think we spent a whole presentation talking about how not to say this is free money. So I won't say that, but mostly free, forgivable money, a loan that's completely forgivable where they want to forgive it the whole time. So EIDL is not like that, but if you borrow $25,000, you don't have to put any collateral up. Any other loan is 25 to 150,000. You are collateralizing your, equipment and inventory, which isn't that big of a deal as long as you're not planning on selling your, for a lawyer, I guess that's really not a big deal. You don't really have cranes or anything like that you would be in the business of selling. And you have to personally guarantee the loan terms is 30 years for 3 3/4%. Your business has to be affected by COVID, 50%. Your income has to go down by 50% or more. And you also have to use the funds to pay any pre-COVID expense that you'd be, not pre-COVID expense, but any expense that you'd be able to have been paid pre-COVID. So you can't, I give the example of if you're a restaurant, you can't add like a deck on to as like a capital improvement onto your space. But you can pay more things than you would have been able to do through the PPP. You can pay your Lexus bill, you can pay, your workman's comp, your malpractice insurance, all that kind of stuff. You can pay through the EIDL. And if you need it, this is the time to do it. We're not sure how long these funds are going to be there. They had closed the program for a long time. So now that it's back open, I would suggest if you think it's possible that you need it and you qualify, maybe it's time to do it. And then you can always pay it back sooner. 3 3/4% is still a pretty good interest rate for a loan. So something to certainly think about. All right. Peter, can a partnership without employees use Form 3508?
Well, I guess the question may be the easy. 3508 is the initial application form. The easy is the simplified method. Yeah, I think a partnership, as long as you can check one of those boxes, you can use those.
Okay. Do S Corp owners get to justify their PPP forgiveness up to $100,000 a year, or do they have to use their W-2 forms from 2019? Unfortunately, you are stuck with that decision you made in 2019. If you took a $150,000 K-1 and a $50,000 salary, that's a shame, but that's what you're limited with. However, if you do have employees, and I don't know if we mentioned this or not, you can use up to $46,000. That's really what we mean by just kidding, it's all forgiven. You took a $20,000 loan on these people, and now you're able to use $46,000 of the funds to pay. You're an employee. It's really incredible how much more flexible this has gotten, throughout the months.
And just the 46,154, and where that number is coming from is just, I'm not messing with the over 154, but just make sure I understand. That's because they're extending to the 24 weeks. So it's pro rata up from an 8-week up to a 24-week period. But I don't think we mentioned that.
Sorry about that. Yes. So that's a great deal. Again, if you had one of those unfortunate situations happen, someone resigned, you didn't rehire them because we're in the middle of a global pandemic, well, hooray, you get to use 2 employees' loan amounts to pay 1. So if that worked out for you, then it's great news. Okay. Next question. Sole proprietor, sole attorney, got $20,000. I put PPP money into a separate account. I was paying utilities from the proceeds. Can I pay myself extra compensation in the amount that I paid for the utilities to get a better tax treatment? Also, solos still can't pay themselves health insurance premium, correct? Okay, so the nice thing about money is that it's all fungible. So when you're applying for forgiveness, you can just say, I applied for $20,833. I took the 24-week, and I am requesting $20,833. I don't even think you need to put any documentation with it. If you do, you can just show the amounts that you paid yourself over that period of time. I wouldn't worry about anything else. wouldn't worry about utility accounts or anything like that. And I know in the beginning I was talking about separate accounts and all of that, and I really apologize. I didn't realize they were going to change the program 100 times and just make it really easy to get and to not audit anyone and to not actually have any care to track what you use your government money for. Who could have seen that coming? So I apologize. I, in the beginning, really did think it was the best practice to have your own bank account. And now it probably is unnecessary. Solos still can't pay themselves health insurance premiums, correct? If you're maxing out on all of your income, it doesn't really matter. You can use the money for whatever you want at that point. We don't have any other questions. Does anyone else have a question? If not, we can kind of go through some other like pretty standard questions we've gotten over the past couple of weeks while we've gone through these changes in the laws. Does anyone else have a question? Oh, none. Okay. Great. So just some other things that people have asked about, going forward, like what does all this mean? So I have some clients who are like, well, the P4 is being proposed. Should I bonus out my employees to catch all of the loan amount that I can use? So that way I'm out of funds in case this new legislation passes. No, don't do that. In the beginning, we harped a lot on bonuses and hazard pay and what we thought you should do. I think some CPAs were actually against it. And then SBA, I think it was May 22nd. Was it like the Friday Memorial Day one? Yeah, good times. So that one, they said, actually, no, you can bonus people, hazard pay, doesn't matter. All of my clients have now opted not to bonus their people because they can actually just extend out their payroll. Christmas in July has been furloughed along with some other things during this period of time. And I would seriously not suggest spending money that you don't have with the specific purpose of hopefully this legislation gets passed and I get the opportunity to get more money. We have no idea what's going to go on. There's $130 billion left in this program, and it's not going to be used most likely by June 30th. So to have Congress say we're going to have a new program, it would have to be really expensive because the money went so fast the first time, or at least like a good chunk of it did. So just whether that's likely or not, I can't really say. I know President Trump said yesterday that there's going to be a new stimulus package. It's going to be a great one. I think that was the quote. So I'm just not sure if that includes something for businesses, includes something like this. Is it a grant? Is it a loan? What's happening? Is it P4? I just don't know. But don't spend money for that purpose. Peter, do you have any like applicable questions you think that people have been asked? And then I think we should probably wrap around 2 instead of 2:30.
I really don't. I mean, last night we were doing some stuff and getting some questions about, unemployment and PPP and how those work together. Just make sure, I think that folks, if you're on unemployment, but you've also gotten PPP, I think you're going to have some issues doing your certifications with the Department of Labor related to unemployment. The goal here is to get people employed again and off of unemployment. That's been included in these IFRs as policy, right? So the government has said that we think it's more efficient, right or wrong, to get people back to work through PPP or get money to people through PPP as opposed to unemployment. Just be careful there. I don't think you can have both things going on at the same time. I think you'll have issues making those certifications. Other than that, no, I feel like we've hit on the big ones. The extension to 24 weeks is big, the 60-40 versus 75-25, neither of which are statutory, but the SBA administrator and the Treasury Secretary have decided that it's within their purview to make that distinction. Otherwise, no, I think we've hit on it. And if there's not any questions, I think we can wrap.
All right, awesome. Well, thanks so much for having us. Sorry for the shortened presentation. But I guess that just means we did a really good job of explaining it if there were no other questions. Again, if there is something that comes up, Peter and I are happy to take those questions on the fly. We understand that these are hard times, and we're happy to give our time in that situation. Just in general, if you are looking for Peter and I, hopefully in the fall, and we are not doing PPP presentations, what we do is we are tax controversy attorneys, which means that we handle any kind of tax-related issue with the IRS or state of Maryland, DC, things like that, any type of audit, sales tax, income tax, once someone's been audited or they haven't been paying, how to kind of handle those large balances and work with those taxing authorities so you can avoid criminal issues, personal liability and things like that. So we're happy to take those questions as well. And, thank you.